The third general exception regarding liability in torts is inevitable accidents. So, inevitable accidents always it negates liability. So, these inevitable accidents can be divided into two classes. So, one is where those which are caused by the elementary forces of nature unconnected with the agency of man or other cause, and the second one, commission or omission in any other causes independent of the agency of natural forces. So, under these two provided classes, we can divide regarding inevitable accident as one of the general exception to determine liability in torts. And in regarding that, we would discuss one leading case, and that was decided by House of Law, and that was Shanner versus Bilton, and that was decided in 1878 by the House of Law. And in that decision, the House of Law held that accident physically unavoidable, where either party have avoided such accident. In spite of that, if the accident had occurred, then it would be held as inevitable accident. And the second important leading case that we will discuss regarding Fairton versus Harcourt Rivington, and that was of 1932, where the Chief Justice of Massachusetts held the defendant took the degree of necessary care, but the damage caused due to some unavoidable reason. So, such damage affords no cause of action. So, in this particular case, the Chief Justice of Massachusetts Court held that in spite of taking all necessary care by the defendant, if the accident was caused and any damage is caused, and that was due to some unavoidable reason, so such damage caused by that inevitable accident does not affords any cause of action. So, regarding these two cases, we found that wherever every care and every necessary measure was taken by the defendant, and in spite of that, if the accident happened and any damage is caused, in such case, the plaintiff would not be held liable as it is falling under inevitable accident. And regarding our third leading case, and that is of Brown versus Kendal, and it was a case of 1859, and it was decided by the Civil Court of Appeal of England, where it was held that the plaintiffs and defendants' dogs were fighting, and during that the defendant tried to stop the fighting between the two dogs by carrying a stick in his hand, and in between, when he was trying to stop both the dogs, the very stick caused injury to the plaintiff's eyes, and here the plaintiff moved to the court regarding actionable claim against the defendant. and it was held that as he was trying to stop the fighting between these two dogs of the plaintiff and the defendant, and he was not aware about the plaintiff's entrance into the spot, and the stick in between caused damage to his eyes, so it falls under inevitable accident. So there was no cause of action. And our next important leading case is regarding Holmes versus Mather, and it was a case of 1875, and it was decided by House of Lords, and in that injury by runaway horses, and in particularly regarding that the defendant took every care and every measure to wound and to keep in his control of his horses, but they became unrest and ran away from the control of the defendant, and they caused certain damage to the plaintiff. Here, in spite of taking sufficient care or reasonable care by the defendant, if the horses caused any damage to the plaintiff, that was Holmes, it falls under inevitable accident. So, the defendant, Mather, was not liable under tort. And our next important leading case is the National Coal Board versus Evans, and it was a case of 1951 decided by the King's Bench. And here there are certain buried electric cable by the defendant, and it was damaged by the defendant, and who was a contractor engaged by the county council, and the plaintiff filed a suit regarding the damage caused to the electric cables let down by the National Coal Board, and here the contractor, the Evans, who was a defendant, he was a contractor and he was not aware about those electric cables, and as he was engaged by the country council, so it was beyond his knowledge or control, so the damage caused to the electric cables of the National Coal Board are falling under inevitable accident. So the King's Bench held that as it was falling under beyond human control, and it is a kind of inevitable accident, so the defendant was not liable under the law of torts.